Hello and welcome to More Than a Game. I'm Patrick Ridge. I'm joined today by John Blaine in the studio, and we are both joined by Samuel Cuthbert, who is a sports barrister at Outer Temple Chambers. A few weeks ago, myself and John interviewed Sam regarding the PSR breaches in the Premier League, the punishments for those. This was in early March, so around the time that Nottingham Forest were having their case heard. It was just after Everton's appeal decision had been published. Since then, Nottingham Forest's decision has been confirmed. The report has been published by the Premier League. They were deducted 4 points for a breach of 34.5 million of the upper threshold of their respective PSR limit. Following on from that, Leicester City were charged with a breach of the Premier League's profit and sustainability rules in the 2022-23 financial year. They have also been handed a charge by the EFL relating to a transfer embargo for now, and it remains to be seen who exactly will deal with their case, but there is a school of thought that they could also be deducted points by the Premier League should they gain promotion from the Championship. And finally, Everton have also had their second PSR hearing completed. The report was published on Monday this week, and they were deducted a further 2 points on top of the 6-point deduction that they were handed out previously on appeal. So, Sam, a lot has happened in the last few weeks. We're going to try and pick this apart chronologically and come to some kind of conclusion or school of thought on exactly what is happening and what is also going to happen with the appeals that are to come for Forest and Everton. So first things first, let's pick up on, because it was heard first, that the Nottingham Forest hearing for their breach of the PSR in 22-23. So as we've mentioned, they were charged with deducted 4 points for a breach of around 34.5 million, and they have outlined their intention to appeal. Everton have subsequently been docked another 2 points for a breach of 16.5 million, and of course were deducted 6 points for a breach of 19.5 million in the first case. So just in those two cases respectively, what does that say about the consistency or the lack thereof of the punishments or the decision making between the independent commissions in each of those cases, and where do you see Forest possibly taking it forward with their avenues for appeal?
Sure. So I think there are a couple of compelling points here. First, obviously, that Forest won promotion having been at the bottom of the Championship when Steve Cooper took over. So they didn't have the parachute payments effectively to increase their revenue, and hadn't been playing in the Premier League for a long time, some 20 years or so, I think. They also had a host of loan players on their books when they went up. So I think it's probably right to say that it was a bigger step into the Premier League for Nottingham Forest than it would be for many other Championship clubs. For instance, a club which had yo-yoed up and down and been able to benefit from the parachute payments. And of course, if they hadn't spent more money on players than their situation allowed, they'd have had very little chance of surviving in the top division. Now, of course, it's right to say that clubs have stayed up in the past without breaching PSR. You know, Luton, for example, but Forest's position was, I think, uniquely difficult. It's probably fair to say as well that the Commission did deal with this, and on sanction goes on to record that 12 other clubs over the last 10 years have been promoted without the benefit of parachute payments the year before. But the period of time that Forest spent out of the Premier League isn't really comparable to those other clubs. And that will, of course, sound in their financial liquidity, their purchasing power, etc., etc. So that's the first key compelling point, I think, which comes out of the Forest decision. And second, this is less of an appeal point, more of a general, I think, point of analysis for the application of the PSR more broadly, is the Brennan Johnson issue. Effectively, waiting to sell your star player at or above his market rate is the sort of sensible and prudent financial decision making that the PSR ought to be promoting. But by imposing sanctions for effectively failing to sell within the accounting period, despite not being able to get as much for him in that period, the PSR appears in that situation to undermine one of its key goals.
So you mentioned Brennan Johnson there, who is referred to in the Nottingham Forest case as Player A, and he is actually brought up as an example in the latest Everton report as well, which we'll of course touch on. But I just thought it's interesting. Would you see that as then? Do you think Forest will really try and press home on that, which they did in the original case as well? But do you think in their appeal they'll really try and fight that argument again, essentially, and stress that the point of PSR is to be profitable and sustainable, and waiting to sell a key asset a few months later to then make the club more money is exactly what the PSR should be promoting. And just maybe from both sides, as both a football fan and also obviously in your profession, do you think that's actually a very strong argument that another independent commission might look at and say, you know, you get a different lawyer who looks at it on a different day and thinks actually they've got a really strong case here?
No, the short answer to that is no.
Very long question, very short answer. I do that, Sam.
The reason I say that is because it's a criticism to be levelled at the rules themselves rather
Indeed.
than their application. And so it's not something which is realistically going to be the task of another appeal board or another independent commission to look at. It's going to be an issue for the redrafting of these rules as and when they happen. Effectively, the rules need to be properly drafted to ensure that they achieve their aims. And if you've got a situation arising where the rules which are supposed to promote financial prudence and stability are not necessarily doing that, or are promoting something slightly different to that, then you need to go back to the drawing board. So yeah, as I said, it's not an issue that's necessarily going to be ventilated in any further appeal, I don't think. But it is certainly something more broadly that the Premier League will be looking at, I would expect, when it comes to redrafting this.
I mean, I think that's very interesting, Sam. And to be candid, I wholeheartedly agree with you, and probably with Nottingham Forest, because these rules were not put forward 10 plus years ago to try and balance sporting integrity. They were there to stop businesses going out of business. And therefore, Nottingham Forest, I think, are probably very upset that what they think is solid business decisions, notwithstanding they have spent huge amounts of money on footballers, but a solid business decision, particularly around Brennan Johnson, has been almost set aside, and they, as they may feel, suffered a larger punishment as a consequence. And I think what we're really exposing here is that the rules as they are being carried out through multiple independent commissions and appeal boards are looking increasingly not fit for purpose, but not fit for the purpose that the Premier League is trying to use them for, rather than for the reason that they were implemented in the first place. So I do wonder what that does to consistency. And what your view is, therefore, that when we get to the end of this process, which fundamentally is Forest's appeal and then Everton's appeal, how we will be able to look back at it and say, for example, the original case, the sanction placed upon Everton in the first independent commission is going to look increasingly unsound, I think. So how can the Premier League get out of this hole in a way where people don't think that, frankly, they have been making it up as they go along?
Well, I think it's difficult. I think with every decision that we get, there is a hope that you'll be able to chart a more obvious logic through the sanctions. But it seems as though the appetite for appeal is always very high, and so you get an IC decision followed by an appeal board decision. You've got numerous lawyers looking at numerous different breaches, and it becomes very difficult to sort of pinpoint an obvious line through it. You know, you look at the issue, for example, the banding that was proposed in the Forest judgment, which was then expressly disavowed in Everton too. It would have been, from a lawyer's perspective, I think, quite nice to be able to chart some consistency through that. You know, there was a proposed banding exercise in one judgment, accepted in the next. So I think there is probably an issue of consistency throughout. As you say, though, John, I think this is probably symptomatic of the fact that these are rules which were brought in more than 10 years ago and didn't necessarily have in mind at the time this level of litigation. I think the one thing that we get out of the last sort of year and a half or 2 years of us talking about FFP in a kind of meaningful way, is there is a tension often between the football sporting process and the litigation process. The two aren't necessarily always the happiest of bedfellows. And I think that the way that the FFP litigation has started to bear out, and there is some inconsistency as I see it across those decisions, only serves to exemplify that.
I think you're right, and that may come to pass when we talk about Everton later, and when the process will conclude, I suppose. And I don't know whether you're going to ask this anyway, Pat, but what do you think the potential is for Nottingham Forest to have a successful appeal from their perspective and get points given back to them?
Well, I'm not on the board, and I'm certainly not hearing the arguments. But as I said at the start, I think there is a good argument to be made in mitigation about the parachute payments and the need for increased spending power, effectively, for clubs that are coming up in circumstances similar to those of Forest. I think that there is obviously going to be an appeal. I wouldn't be surprised if there are further points which are deducted, but I won't put it any higher than that.
Further points deducted, as in given back to Nottingham Forest, you mean?
Given back to Nottingham Forest.
Yeah.
Deducted from the...
Yeah, I mean, I'd like to challenge you, actually, and I don't think it's a legal matter, so perhaps it's just you as a football fan from another football fan. I have a real personal problem with the fact that Nottingham Forest described their case as unique, and you seem to be giving some force to that argument, because surely you stick to the rules until you get them changed, not complain that the rules are wrong and then get a lesser punishment simply because a judge agrees with you.
Well, I don't think a judge would necessarily accept that the argument that you just because you're in a unique position that you are able to breach the rules. I don't think that would effectively go to being able to extinguish or diminish the breach. But it does set the breach into context. The need for it to happen. I think there probably is a mitigation argument to be had there, which hasn't necessarily played out as fully yet as it may have done. But I accept, of course, that as I pointed out previously, there are a number of clubs who have come up from the Championship and have managed to stay in the Premier League without necessarily incurring those breaches. And as I say, I don't think a judge necessarily would accept the point that I referred to. But I think what's really going on here is that we're drawing attention to a much bigger issue, which is that smaller clubs who haven't been able to play in the Premier League for however many years, haven't had the benefit of the parachute payments for however many years, are going to struggle against teams who have much bigger spending power. And if the PSR are restricting their ability to effectively stay within the league that they've worked hard to get into, then that's a fundamental principled issue for the rules as they currently are drafted.
Yeah, I think it becomes circular, to be honest, because Nottingham Forest, of course, were in breach of the rules in the Football League as well. And clearly they've spent lots and lots of money. And I think the nub of this, you're right, sits quite squarely on what are these rules for? Are they trying to balance sporting integrity, or are they trying to stop businesses literally going out of business? And someone like Nottingham Forest has got a huge lift in income from the broadcast revenues that Premier League clubs enjoy. We're never likely to go out of business as a consequence of what they've been doing. I also suspect, and I hope to some degree, notwithstanding it might not be good for Everton, that there should be some force in the argument that they did the right thing and getting £20 million more for Brennan Johnson, or whatever the number was, as long as, of course, it can't be demonstrated they then spent that money in advance anyway and subsequently spent it in the following January. So yeah. We're into really as you rightly say, I think some structural challenges here about whether these things are fit for purpose or not. And I think the fact that the Premier League, Sam and Pat, are going to change them suggests they know that, but they're continuing with prosecutions under what appear to be rules that are not they're not satisfying what they're supposed to do when they're tested under stress. So it is where we are, unfortunately.
Yeah, I think that's entirely fair.
Well, Sam, we'll briefly now touch on Leicester, because I think we talk about, you suggested that the waters are muddy, aren't they, at the minute, everywhere, and no muddier than in the Leicester case, in my opinion, the sense that you've now got a club that is currently in the Championship, that got relegated last season, very much pushing for promotion, but they have been charged by a league that they are not currently in. If they are punished, it will be in a season after when the Premier League want these in-season deductions, so it'll actually be 2 campaigns after they committed an offence or a breach. Just your opinion on the Leicester case from looking at it overall. Do you think that the fact that they are pushing hard back against the Premier League and the EFL in issuing legal proceedings against them both? Nick DeMarco will be representing Leicester, I believe, after he's represented Forest. Do you think that further muddies the waters? Do you think it further complicates things for the club as well? We've seen that Forest did get some mitigation, and Everton limited mitigation for cooperating. Do you think in Leicester's case that cooperation, that mitigation, that option of mitigation is going to be gone, given that they are issuing legal proceedings?
So this is an interesting position. I think, let me just to break it down quickly before I give you the substantive answer here, which is, so Leicester have long argued that they shouldn't be punished by the EFL for PSR breaches because they weren't in the Championship for much of the relevant period of breach. But they also appear to be arguing that they shouldn't be punished by the Premier League, as they're not currently in that division either. So it's not difficult to see that there's a tension between those two positions, right? And then, having been either charged or punished by both, Leicester have gone on to now confirm that they're pursuing legal cases against the Premier League and the EFL. So as at the moment, it's not precisely clear what the substance of those legal proceedings will be. And the statement from Leicester on this was fairly ambiguous. I'd imagine that they'd be seeking a declaration of some sort as to which league has jurisdiction to bring proceedings and for what periods, something like that. And if that is the case, it may well be a helpful step in clarifying how EFL and Premier League FFP breaches effectively interact. So if we get a declaration or a judgment on that, I think that would be a helpful thing. As far as relegation or promotion go, which is something you touched on, Patrick, I think Leicester will be sanctioned by at least one of the EFL or the Premier League, and if that's the case and they start next season in the league which is sanctioning them, we're likely to see them start next season in a points deficit, I would imagine. If, on the other hand, though, for example, a situation arises in which the EFL sanction Leicester get promoted and no Premier League sanction is received, for example, it will be difficult for the EFL to enforce that sanction, or for that sanction to sound in anything but a fine, because what you're effectively doing is comparing apples and oranges. You've got you'd be trying to impose points deductions from the EFL in the Premier League, and that just can't be the case.
It's
what a mess.
Yeah, incredibly complex situation. And I can't help but think back to Richard Masters in front of the committee hearing back in January, when he said with a straight face it wasn't messy, and then in the meantime this is what's happened. Just finally on Leicester then, do you think that their resistance to submitting a business plan to the EFL, which in fairness was backed up by an independent commission, they sided with the club on that, saying, well, you didn't have to, but it then seems like that gave the Premier League almost an authority maybe to go after them. Do you think maybe they'll be regretting that decision after all, because they could have submitted a business plan to the EFL?
Well, I think it's difficult to answer without having the inside line from the Premier League what the impact of that decision would be. I certainly wouldn't imagine that this would lead to any further scrutiny from the Premier League. The system effectively is that the clubs put their accounts in at the end of the year. The accounts are scrutinised as a sort of a matter of course by the Premier League, by the EFL. I think it's probably worth at this point doing a short explainer here, because the Leicester's run-ins with the EFL might seem slightly impenetrable to those that don't work in this space. So, I mean, to give listeners a background, Leicester were initially on course to breach the EFL PSR by the end of the season, and it's important to note that those are different rules to the PL rules, of course. The EFL then, by way of the reporting unit, the club financial reporting unit, issued their determination, and you may have read about this, that Leicester submit a business plan which would then be ratified and enforced by the EFL, which would effectively be aligning the club with its duties regarding kind of financial compliance. Leicester then take issue with that because they were in the Premier League for the lion's share of the period in question. They argue the Premier League rules rather than the EFL rules should apply, take the matter to the club financial reporting panel, who agree with Leicester that the club financial reporting unit had acted beyond its powers. We then find ourselves with that unit issuing a second determination that Leicester submitted a business plan based on financial information received after November 23. So as well as future financial information forecast provided to the unit. Now that didn't at the time form part of the matter before the panel, and Leicester haven't contested the suggestion that they were in breach of the PSR rules for that period. But what this really goes to is how complex these matters are. What we're dealing with are hugely difficult accounting matters that need determining in a way which is sufficiently straightforward to align with the certainty that comes with the footballing, the sporting process. And even in me having to explain it in such kind of granular terms, I think demonstrates the difficulty and the tension between those two things as it currently stands.
I think you're right, Sam. Again, that they are. I don't like the word complex, as I always say. That complex is just lots of simple things joined together. But when there's so many of them, it does get incredibly difficult to find a path through it. And of course, Pat, maybe we do a segue into what's happened with Everton on their most recent independent commission, which fundamentally seems to have had started off with a dispute between the two parties on actually what the size of the breach was. And that seems to be differences of opinion about accounting practices. And so we are in that crazy situation where lawyers and forensic accountants are, the new star players of Premier League football clubs. And it seems madness. But what was your initial take on the sanction levy to Everton at this time, and how it relates to what's happened previously?
Well, I was speaking to a friend the other day who described it as number wang. I don't know if that's a reference that you're familiar with, but as I think we were discussing earlier, it's feeling a lot more difficult to be able to chart a kind of consistent and logical route through all of the various sanctions. We've discussed the banding issues. I think even last time I was on the podcast, John, I agreed with you that future sanctions were likely to be somewhere between 3 and 9 points, and well, we've both ended up with egg on our face, given that this a 2-point deduction which has been handed down. What I think is probably fair to say to the Independent Commission in this case is that once they'd arrived at the 5 points, there is a logical process for awarding points or removing points deductions in mitigation, and I think that's something which is helpful and provides some certainty, much needed certainty as regards how mitigation ought to be dealt with.
No, I think you're right, and in some respects, the later in the process that we've got, the more sense the intra relationships between mitigation, aggravation, and the starting points have become easier to understand. I think it's the consistency across the cases that's the problem. And if you look at what you just said, the Everton case, the most recent one, had a starting point of 5 points, and we have clarity about, and there's a question there about whether it fits with the Forest one. But it's pretty shocking in my mind that Everton ended up with a 6-point deduction for a 19.5 million breach the first time around, and they've ended up with a 2-point deduction for a breach that's £3 million shorter over 3 years.
Yeah.
That's farcical, isn't it?
There are definite inconsistencies across the Forest and Everton 2 judgments, and that's not the only one. Forest were awarded 2 points for what's been reported in the press as good behaviour, but there's been inconsistency between the respective decisions in the Forest and the Everton 2 cases as far as cooperation goes as well. So of course in Forest case the Premier League accepted the admission was at the earliest opportunity, and that in itself warrants a reduction in sanction by a maximum of a third. And that decision set out that effectively Forest Corporation significantly reduced the costs of enforcement, assisted the Commission, and then in the decision they even go on to say that it was desirable that kind of cooperation should be recognised and given credit. Because I think they go on to talk about appropriate incentives for responding clubs in future PSR cases. So it's very clearly trying to set out how this might be dealt with, how the issue of cooperation might be dealt with in future cases. Compare that to Everton 1, where the appeal board identified that cooperation with the Premier League is not itself a mitigating factor that provides for kind of any lesser sanction following the breach of the PSR. And the appeal board in Everton 1 made the point that because the Premier League operates as a joint venture where each club agrees effectively to be bound by the rules and regulations, distributing profits, etc., that the cost of enforcement of the PSR against one club falls on all the clubs by reducing money available for distribution. So the appeal board made the point then that on a basic level of compliance with reporting requirements, effectively grounded in that idea of a joint venture, it should be expected that cooperation, or only cooperation over and above expected cooperation, could amount to a mitigating factor. So you've got two very different positions as far as cooperation goes, emerging in the Forest case and emerging in the appeal board's decision in Everton 1. Now, it may be that the Premier League would say, well, early admission amounts to cooperation over and above what's expected. But I think that's difficult to see. Well, it's difficult to understand how that wouldn't just be the standard provided for by the PSR, as outlined by the appeal board. So I think what again, this goes back to, there is a variance in the way that these issues are being dealt with across appeal board decisions across the commissions. And in the case of Forest as against Everton 1, that's quite a stark variance, particularly in respect of how cooperation is dealt with. And of course, cooperation is going to be hugely important and something which is to be encouraged. So as to avoid this heavily litigious landscape in which we found ourselves.
Yeah, and just to pick up on that, Sam, I think so the Forest, in their argument, they obviously put forward that they should be given a third back alone of any deduction, a third back for the early guilty plea, and then on top of that, their exceptional cooperation getting some further mitigation. And the commissions disagreed slightly, and it gave them 2 points back combined for those factors. And in Everton's case, if we it can't be exactly broken down like this, I'm aware, but if we broke it down to a simple mathematical formula, it appears that Everton have been given half a point back for an early plea and then half a point back for another mitigating factor, which was USM, which we will, of course, touch on. But one paragraph that I'm sure you've read it, and it has stood out to me and a lot of Evertonians and a lot of football fans in general, is 256, which is where the Independent Commission in Everton 2 specifically speak about this cooperation argument, this back and forth between the Premier League and Everton, when it's a bit he said, she said, a lot of stuff being thrown at the wall by both sides. And 256, the Commission write that in our view, many, if not most, of the criticisms levelled against the club in this respect by the Premier League are unwarranted, overstated, or both. Now, let's be clear, this is in specifically to the cooperation argument. Do you think that is a bit of a win for Everton in that sense against the Premier League? Obviously, they haven't received any points back for it, but it does go some way to show that maybe there was a bit of overzealousness on the Premier League's part.
I very possibly, and I wouldn't be surprised if that does materialise as a ground of appeal, as and when this is appealed. I think ultimately the Premier League won't, I would imagine, balk at the idea of being accused of zealousness, because from their perspective, they are their rules, they are to be followed, and they need to not only apply the rules, but be seen to be applying the rules, and ensuring that proper enforcement happens. So yes, I think it may be that there has been some zealousness, but ultimately, this operates in the same way that any kind of litigation operates. It is a question of both parties putting their strongest point forward, making the arguments that the strongest arguments they possibly can on any given point. It is necessarily going to be the case that at certain points you end up making an argument which is slightly weaker or slightly more zealous than might be desired by the tribunal which is hearing it. A good example, I think we're going to come on to it in relation to the USM issue. The commission, I think, said something along the lines of the arguments about poisoning Russian dissidents on UK soil, and/or Russia's invasion of Crimea should have given Everton pause for thought as regards whether they carry on being sponsored by Russian companies. And I think that the judgment was something along the lines of, well, that's a very nice in hindsight. That's an example of how these kind of arguments work. You have inevitably weak and strong parts of your case, but you need to put an argument in any event, and I think that's probably what's happened here on the PL side.
I find, yeah, we're all smiling here, I think, Sam. I found much of those examples, and there was a litany of them because they all went through one by one. Some of them were really quite petty, and I think there was a lack of, or a loss of understanding, certainly on one side, of why these people were all in a room, because they were trying to stop a football club allegedly going out of business. But we covered off that before. You did make the point, of course, that apparently Forest got some benefit because they saved some money for the Premier League ultimately. Yeah. And frankly, a very petty implication being that means more money goes to grassroots football, which I find quite hilarious, right? But it also happened in the Everton most recent case that for the reasons of expediency, to seek to try and reach a conclusion on this complaint within the time available, they split the complaint into two parts. And one part has been dealt with, and Everton have suffered a point sanction, a deduction. What's your thoughts on splitting it into two in the first place, and what impact this may have in the whole process, on the basis that it's quite clear that part two isn't going to get concluded in time to impact this football season, and it'll probably happen in a future football season?
So the commission have effectively said that a hearing is going to be needed to determine further PSR breaches in respect of accounting practices, but specifically to deal with issues like the retrospective capitalization of sums in the financial year 21-22, and then the capitalization of interest relating to the financial year 2023. So that specific dispute is really about how Everton have been accounting for some of their interest payments, and whether those payments should be excluded from the club's annual profit and loss account, which of course forms the basis of any club's PSR submission, right? So it seems from the decision, at least on my reading, that the main reason for not dealing with that now was really a timetabling one, potentially one born out of the fact that the issue, as I understand it, arose as a later amendment to the Premier League's case, and I think is realistically going to require quite a lot of expert accountancy evidence in order to properly deal with it. What I think this really goes back to is the point I made earlier. Effectively, the decision it draws attention to the difficulties posed to stakeholders by putting this issue off. There is a problem there, but this is a classic example the litigation process and this kind of sporting competition not necessarily rubbing along particularly well next to each other. You've got on the one hand a circumstance where you will need a significant amount of complex and I would imagine very expensive expert accountancy evidence, and that's going to take time to thrash out. It's going to take time to hear and to test. But on the other hand, you need, an expedited decision to reduce the issue of asterisks being left by the names of clubs at the end of the season, and to ensure that there's proper certainty as to which clubs are going up, which clubs are going down, and who's won and who's ended up where. So it really goes back to, I think, what seems to be the theme of today's podcast, which is litigation and sporting processes don't always rub along particularly happily.
I think that's fair, and if you allow me, Pat, before you might get into summing up or give us other challenges, but I've worked in business for 30 or 40 years, right? And I've worked for publicly listed companies. I've sat at board level in FTSE 100 companies, and I've dealt with auditors and law firms almost as a matter of course. And I spoke with a retired partner from Deloitte this morning, Deloitte being one of the largest accounting stroke audit firms in the world. And I'll just leave this hanging there rather than go into any great debate about it, mainly because I'm going to ask the guy to come on the channel. And he said the Premier League can't make up accounting rules just for one club. And it's interesting that a legal view may be that this is all going to take quite a long time to resolve, and a lot of expert witnesses and all those sorts of things. But ultimately, I think Premier League may be losing sight of what the ultimate end in mind here is, which is credibility for the rules themselves. And it just seems crazy to me that the implication in the Everton Commission judgment is that the Premier League seems to be questioning not just Everton's accounts, which means they're questioning Everton, but the fact that those accounts have been successfully audited by an independent company, which means they're then questioning the competency of the audit firm. And that is not a place anyone wants to go. Because, as you rightly said, lots of what you described about the second part of Everton's complaint being addressed is going to be a very expensive academic exercise in my mind. And I'm not sure we'll come out the other end with any greater clarity than we have now, considering in parallel the Premier League are going to change the rules.
Yes, I think it certainly feels that on the one hand, these issues need dealing with. If the Premier League raise them and say that there is a case to answer, then they are obviously within their rights to bring that and ensure that those are matters which are properly ventilated. But on the other, it's hard, I think, to fully appreciate the significance of that, whilst also looking at the potential for a kind of rules overhaul in a matter of months or a relatively short period from now. Lots of money, lots of time, lots of energy being expended on something which very shortly might be entirely redundant. There's certainly an argument to be had there as to at what point do we have to draw a line under some of these accountancy practices, under some of these breaches, and start again. Because I suppose even as and when the new rules are brought in, there will still be the opportunity for the Premier League to sanction or at least bring regulatory prosecutions for historic breaches. It's, I suppose, happening with Man City, happening with Chelsea during the Abramovich years. It may be that a practical approach has to be taken at some point, and certainty as to the league, certainty as to teams going up, teams going down, who wins, who comes second, etc., takes precedence over historic breaches of PSR and FFP rules.
Yeah, it seems like it would be a sensible approach, doesn't it? And I think John has a phrase of in the foothills, and it seems this Everton, this accounting differences are a bit in the foothills of the Man City case in a way that there's similarities there. And obviously we've seen how long, well, we don't know how long that's going to take, but there is certain similarities with the Premier League's questioning on that line. So just to finish off on the Everton case, and before we finish off altogether, Sam, do you mind? We spoke a bit in the last podcast about the possible avenues of appeal, and we kind of came to the common sense that double jeopardy, for lack of a better term, would probably one that Everton pushed, and also the loss of the sponsorship of USM. And you spoke specifically about the loss of chance argument, having sanctions to hook that around. Loss of chance, you may have seen, is a phrase that is used in relation to USM as well in the Commission's report. So do you mind just giving us a quick summary of the mitigation that was accepted for Everton in Everton in the way that you see it?
So as I think as you point out, this was something which was discussed the last time I was on. The Commission effectively rejects the idea that Everton shouldn't have placed all its eggs in one basket, which is what the Premier League said when it comes to relying on money from USM. And what the Premier League was saying was that Mr. Usmanov had a heightened risk profile, and so it was silly for them effectively to rely so heavily upon him. On this point, the Commission accepted the exceptional, I think, and unforeseeable circumstances which led to the loss of the £20 million in revenue. And then they go on actually to draw attention to that credit being seriously limited by the business decisions made by Everton during financial year 2023. So on the one hand, they accept the mitigation as put forward, but then go on to say, well, actually there were some business decisions which left much to be desired, which go some way to not extinguishing, but certainly making up some of the ground that the mitigation removes. So Everton definitely had the stronger argument here. I think the Premier League's position, i.e., and this is something we talked about previously about the invasion of Crimea, the poisoning episodes in the UK, that they were the necessary red flags that would have given the Everton board pause for thought. That they were held to be kind of a nice point in hindsight. Ultimately, though, that it would be too much to ask that Everton should take those matters into account when they were considering kind of prudent management of sponsorship risk. That I think has to be right. And so the position we find ourselves in is that, in summary, Everton's mitigation in relation to, firstly, the loss of the revenue they would have received pursuant to what's been called the Finch Farm Agreement, which is effectively all of the stuff coming from USM. And secondly, that their guilty plea, that they were taken together to result in a further reduction of 1 point, which is then how you get from the 5 down to the 3, and then to the 2 points, which were finally imposed as a sanction.
Yes, absolutely. And so the double jeopardy argument is where it was essentially that the Commission did a bit of a calculation, didn't they, and worked out that if taking a 16.5 million breach, it was just under 50%. So just under 50% of 5 points is 2 points. I think that's fair enough to say, and that got taken off as well.
So the sanction really starts with the double jeopardy argument.
Yes.
And this is an interesting and probably just worth me exploring it briefly. The Commission made clear in the decision that the EFL guidelines, which set out the position that the EFL would take where a sanction has been imposed previously, that they were a helpful benchmark, but couldn't be transposed directly into the Premier League rules, not least because the Premier League had made no provision for such guidelines. And as we discussed earlier, it's a joint venture, and it could have done that if the clubs had wanted to. As far as double jeopardy goes, the Commission held that it was incumbent on it to acknowledge that any sanction on Everton in respect of the financial year 2023 needed to be reduced in order to reflect the fact that Everton had already been sanctioned for years, which are also included in the current PSR calculation for financial year 2023. And so the 2 point sanction was arrived at. They arrived at that by determining that Everton had already received a penalty for just under 50% of the loss, which has now led to it being in excess of the upper loss threshold. And so the maths effectively followed that it would be appropriate to reduce the penalty by a half. Mm-hmm. Now, they in fact went from 5 to 3 because they were dealing with whole numbers, and they then the additional point was removed for the further reasons of mitigation, i.e., the early plea, the USM point, which we spoke about.
Yeah, well, when they get into removing half points, I think that when it will be all time to pack it in, won't it? Or removing certain goals or anything like that. Well, Sam, thanks for joining us again. It's been a fascinating chat and really appreciate your expert analysis. Some fantastic points discussed as well. So thank you for joining us. I mean, who knows? We might well be getting in touch again. You might well be appearing on another podcast.
Oh, we will. We will.
I'm sure. When we get the results of the Forest appeal and ultimately the Everton appeal as well. And let's hope for everyone's sake that it at least doesn't drag on until the final backstop date of May the 24th, when I think that would be egg on the face for everybody, wouldn't it, involved if relegation is decided after the season is finished. So thank you very much for joining us. Thank you. Thank you for watching More Than a Game. Thank you for tuning in on the podcast. Please subscribe to the YouTube channel. Subscribe to the Substack, mtag.substack.com. We have fantastic pieces by myself, likes of Harry Card, John with his business,
I write stuff.
with his bi-weekly business columns, which are always a great hit and very popular. So please go and check out the Substack as well. Thank you.